Hello guys, how are you? As I promised that we will have revision series for the upcoming Bihar Judicial Services Examination 2026, right? And we will basically do this series regularly from the 1st of May. In the light of the recent order from the Honorable Supreme Court, we all know that the last date of the form submission has been extended up to 30th of the April. There are speculations that the examination date might also extend, but we will not go with that. We will start with our preparation right from the very first day. The 2 months period from the 1st April till the examination, considering that the date does not change, that is the 30th of the May, is quite sufficient for the revision and in a way to start. It is good amount of time to prepare for the prelims examination if we have read priorly about the syllabus and we have been a bit serious previously, if we are serious aspirants of the judicial services examination. So in this video, as you can see, that the last video that we published was about the BNSS, that is Bharatiya Nagarik Suraksha Sanhita, the changes that has been made over the CrPC, that is the Criminal Procedure Code. The new law was brought in year 2023, as we all know, with few of the changes, and there is high probability that these changes might be asked in the examination. Though the evidence and procedure has not much of the weightage in the prelims examination, but considering the fact that this time it might be asked, because this is the first time that the Bihar Judicial Services Examination is being conducted after the new law has been passed. So considering this particular fact, we are focusing on this particular aspect. We will be discussing the highlights of the BNSS as well as the other two criminal laws, that is Bharatiya Nagarik Sanhita, that is BNS, and the Bharatiya Saksha Adhiniyam, that is BSA. Bharatiya Nagarik Sanhita, as you know, is a replacement of Indian Penal Code IPC, and Bharatiya Saksha Adhiniyam is a replacement of the Indian Evidence Act. We know that, right? In the first video, we looked into few highlights of the BNSS. These highlights are basically the changes which has been made and basically new additions which has been brought into the new law. And today in this video, we are going to again discuss few of the highlights. So basically, your job is to listen to it carefully and keep this as the revision series, as I always say, that you just have to put on your headphones or you just have to keep the phone aside and just listen to the content. So in this video, let me start with that the judicial magistrate, as I said, as we discussed in the last video itself, that there has been changes. The three positions of the judicial magistrates has been 2 positions of the judicial magistrate and 1 position of the assistant session judge, right, has been removed, and though therefore there has been changes in the jurisdiction of the judicial magistrates as well. Earlier, the judicial magistrate class 1 had a jurisdiction of 10,000 rupees, this has been increased to 50,000 rupees. This is important that the judicial magistrate first class jurisdiction, monetary jurisdiction basically, has increased from the 10,000 to 50,000 according to the new law. Now, judicial magistrate second class, their monetary jurisdiction has increased from 5,000 to the 10,000. What does it mean? That any case pertaining to this particular limit of monetary jurisdiction, suppose there is a theft matter which is basically of 10,000 rupees or say 40,000 rupees. So this case will come to the judicial magistrate class 1 because it lies within the if it is more than 10,000 rupees, it is, and up to 50,000 rupees, it will come within the jurisdiction of judicial magistrate class 1. Then judicial magistrate class 2, as I said, the limit has increased from 5,000 to 10,000 rupees. Anything below the 10,000 rupees, any case where the money matter is below 10,000 rupees, then such cases will come to the judicial magistrate class 2nd. Right. Now, punishment such as new punishment which has been added to the BNSS is community service, as we know, and this has been the highlight of the new law. Now, judicial magistrates can also provide community service. One question that is asked: what is community service, and who will decide what is the community service? So, as per the law, if you read into the provision section 23 clause 3 of the BNSS and its explanation, basically the explanation of section 23 clause 3, it defines community service, and it is the work which the court may order. So while at the end of the trial, when the accused person is found guilty, and now it is the matter for the punishment, it is the hearing is going on for the punishment. The community service can be given to the accused person, and this will be written in the order of the court. So community service will always come from the court. There is no list of community service. Right. So the court may order the community service to perform as a form of punishment. And this kind, now community service cannot be randomly prescribed by the court. The purpose of the community service is always to benefit the society. Right. So understand that. I will give an example. If an accused is found guilty and the court has to order some kind of community service, then the court cannot order that go and dance for somebody, right? Go and sing for somebody. No, these are not the community services as per the law. The law says that the community has to benefit. The society has to be benefited by the community service, right? So the community service punishment in the form of punishment should be of the nature that it benefits the society in any other form, like go and plant some trees, go and help in go and do some service at the charity places and all those things. These are the community services, right? And for this community service, he or she shall not be entitled for any monetary remunerations. ऐसा नहीं है कि पैसे मिलेंगे उस community service के लिए. So this is a form of punishment. Somebody is also, I mean, few critics also say that it is kind of begar, right? Forced labor or a free labor kind of thing. But that is not part of our discussion for the judicial services examination. We just have to follow the law, what has been said by the courts and by the statutes. Now, see, earlier there was a provision of punishment being running concurrently or consecutively, meaning that if there is a trial which is going on for a case, and in that case there are more than one offenses. So what happens if the accused person is found guilty for all the offenses, for both the offenses? That in that case, earlier, you know, it was written that it was running, one after the other or concurrently, whatever it was written. But the present position is that it is the court to decide, and that decision should come from the on the basis of the gravity of the offense, and it is the court to decide that the punishment to run the concurrently or consecutively. Now, earlier there was some confusion whether the court has to you know court should give the concurrent punishment or consecutive punishments. Consecutive punishment is that one punishment ends and then the second punishment starts, and concurrent is the punishment for all the offenses will go simultaneously, and that way ideally the accused person, the convicted person in fact, will stay inside the prison till the punishment of the offense having the largest number days of punishment is over, right? And this new thing that now it is the court to decide whether the punishment will go concurrently or consecutively will be based on the gravity of the offense, and this has been prescribed in the section 25 of BNSS. Okay, section 25 BNSS talks about it, right? Now there is another new addition which has been made is in section 35 clause 7. This is about the arrest of persons. If you read into section 35 clause 7, it says that if an offense is accused, if a person is accused of committing an offense whose punishment is less than 3 years, right? And in that case, if the person itself is more than 60 years, 60 or more than 60 years of the age, then he shall not be arrested unless it is being necessary made by the police officer, but not below the rank of DSP, this Deputy Superintendent of Police. That the general rule. So the general rule is that there is a person who has committed an offense, not committed actually, I won't say committed, a person of age 60 or more is accused of an offense whose punishment is less than 3 years. Now general rule will be that that person will not be arrested. But if circumstances are so that the person shall be arrested, then it should have a permission, prior permission, meaning that the IO, that is investigating officer, can only arrest that person with the prior permission from the DSP, that is Deputy Superintendent of Police. Any officer of the rank at least of DSP or more, right? Now let us come to section 40. Section 40 is again there is some change which has been made, that if it is about the arrest by the private person, and it says that if a person is arrested by a private person, then that person should be brought within the nearest police station, to the nearest police station within 6 hours, right? This is the change now. Now if so, CrPC also provided that the private person can arrest. Similarly, BNSS also provides now that the private person can arrest. But now that private person shall be produced to the nearest police station within 6 hours. This is the change, and this has been given in section 40. Remember that. Now let us come to section 63, which talks about summons. Right now, summon can be in electronic form now. So this is one of the this is one of the most prominent additions in the new law, looking into the changing in the way things are working nowadays, looking into the relevance of electronic form of communications. Now the summons can also be served through electronic form of communications, electronic medias, personal electronic medias, in a way, meaning that if the WhatsApp number or the email ID of the accused person is ready with the investigating agencies, then it can be transferred through the electronic mode of communications, right? Similarly, service of the summon, which is provided in section 70, also talks about the service can be made in electronic form. Let us now come to section 66, which talks about the gender neutrality. Suppose earlier what was the rule is that when the someone is brought, someone is sent to, or someone is brought personally by some, say, post office staff or the police officer or anybody who is responsible to do so, in the absence of the accused person, the summon was to be handed over to the male adult member of the family or the society nearby. But now the summon can also be delivered to the female members, meaning that it has been made gender neutral. Now earlier the case was that the summon could only be delivered or can be handed over to the male adult member of the family. Now it can also be given to the female adult. So it has in a way made gender neutral. Section 66. Remember that. Now let us come to the next provision, that is section 84. Section 84, clause 4. It talks about the proclaimed offender. Right. Now proclaimed offender can be declared in all offences which are punishable with the punishment of 10 years or more, or with life or death. Meaning that now the proclaimed offender can be, any person who is accused of these offences can be proclaimed as the proclaimed offender, can be declared as the proclaimed offender by the court. This is provided under section 84, clause 4 of the BNSS. Now section 86, this is a new addition in a way, which tells that police officer not below the rank of superintendent of police, SP, may make a written request to the court. And what request? This is to process the attachment of property of a proclaimed offender outside India. So suppose there are few, if an accused person has the properties outside India, then those properties can also be attached now as per section 86. Remember this, 86 important, right? And this can only be made via court order, and SP can only request. SP can only request the court to pass such an order. So this is important. Now let us come to section 94. Now, production of digital communication devices. So it talks about the digital evidences, right? This is again a new addition to it. So there are few devices which are digital in nature and which the investigating agencies think that can be used as the evidence against the accused person. Now, earlier it was kind of prohibited. Now it is allowed under section 94. More of it can be discussed under BSA, that is Bharatiya Suraksha Sanhita, because these are the matters of the Evidence Act. So anything which is of the Evidence Act is more detailed discussed in BSA, that is Bharatiya Suraksha Sanhita. Now let's come to another section, that is section 105. Now this is important. What he says, it talks about the videography of the process of search and seizure. Now, if there is a requirement by the law to search and seize the premises of the accused person, the same has to be video recorded now. The whole process of searching and seizure has to be well recorded. It has to be videographed. And the best part is that it can be done by the mobile phone as well. We do not need to have those professional expensive cameras to do this. Now the investigating officer can easily record or videograph those processes of search and seizure through the mobile phones. Right. Now, another thing that we can discuss is section 107. This is again important. Remember this, and this can very well be asked in the examination. It talks about the provision of attachment, restoration of proceeds of the crime. So see this, PMLA, we know that there is a law called as PMLA, Prevention of Money Laundering Act, and there is something called as proceed of the crime. What is the proceed of the crime? A proceed in the form of monetary or any kind of anything which has a value, some monetary value. If that has been acquired through some form of the crime, then that could be restored or attached through the now under the BNSS. So proceed of the crime, suppose somebody is doing money laundering or somebody is stealing something, somebody has fraudulently taken off the property of some other person, so that can be restored and attached now under the provisions of the Bharatiya Nagarik Suraksha Sanhita, that is BNSS, and this is provided under section 107. Now under maintenance, now section 145 talks about the maintenance of the father, mother, right? It talks about the maintenance of the father, mother, child and wife. So in the case of 145 speaks that in case of dependent father and mother, in the case of dependent father or the mother, the proceeding for order of maintenance may be initiated at the place where she or he resides. पहले क्या होता था? The proceedings used to happen at the place where the son resides, but now the same may be initiated at the place where father or the mother, whoever has either individually or both together, father and mother, have filed, a case. Now that proceeding can be initiated at the place where either the father or the mother or the both resides. So this is section 145. Now section 162, it is related to the public nuisance. Now earlier the public nuisance related cases was being handled by the DM, district magistrate, SDM, that is subdivisional or sub district magistrate, executive magistrates, etc. But now it can also be looked after by Deputy Commissioner of Police, DCP, Deputy Commissioner of Police, right? So this was basically part 2 of the series where we are discussing BNSS highlights or the new criminal law highlights. This will continue from 1st May 2026. Not 1st May, 1st April 2026. We will have a regular discussion and we'll fix a time itself in some evening, evening itself, or maybe in the late night, as per the convenience you guys may decide and comment in the comment section. So now with this discussion we end the discussion which we were having today, and I hope that this video is of some use to you. If you think that it is useful, you may share this video to maximum of the people so that those who are preparing for the judicial services, especially Bihar Judicial Services, get benefited out of it. And I value your time. We will never discuss anything which is not relevant to the judicial services examination, right? With this, I end the today's session here itself, and I wish you best of luck and keep studying. This is just revision. Continue your normal study that you are carrying out as per your timetables and conveniences. My job is to revise each and everything that is relevant to the prelims examination, and I'll do that. Along with the law, I'm also thinking to start the sessions for the GK and GS. So if I get good response in this particular series, then we'll also start with the GS and GK, right? Thank you very much. Namaskar. Have a good night.